First topic of this issue is from Deputy Arthur Spring to ask the Minister of Finance the terms of redundancy offered to the staff of IRBC. Deputy Spring, you have 4 minutes.
Thank you, Count Corla. First and foremost, for the order of the House, I would like to bring to the attention that I'm a former employee of this organisation and I have former working colleagues still in the House, and I would like to say that some of them are friends of mine also. I would like to point out that this is an issue of fairness, however. Fairness and justice for people who were not responsible for the downfall of Anglo-Irish Bank or Irish Nationwide and have been working for the state on behalf of the citizens and taxpayers in order to put right what some few people put wrong. The people that put it wrong were senior management, directors, and people that didn't have a day-to-day job that was more relevant to what the average industrial wage was. They have taken public abuse, they have been held responsible publicly, they've been held responsibly socially, and they have been vilified by many members in the House without any comprehension or understanding what it's like. They have been subject to the type of abuse that many of us have got over the last 2 years and the previous government would have been recipients of also. Where we're bringing this is because of the terms and conditions that were highlighted to the employees that sit in place and do an honest day's work for an honest day's pay. To put it mildly, the pay was one of the lowest of all the banks for the people that were working on the front line. The ratio that you would look to is all about how you look at income-cost ratios. The income of the bank was very high, the cost ratio was quite low. That's because people were paid quite often in share options, what I call the golden handcuffs. And as a Labour Party, we believe that people should be looked after for a day's work. And if you tell them that they're going to be entitled to a redundancy package, you live up to it, particularly if the state is involved in this. The information that has been provided to me suggests, and I'd like to quote some of it to you if I can, by Gary Marshall, who was appointed by the Department of Finance as the Chief Operating Officer. This is a correspondence of the 5th of September. Further to my last update on the bank's ongoing consultation process. Voluntary redundancy, terms to be offered to all eligible employees, were agreed between the bank and the authorities over the weekend. I can confirm that subject to certain terms and conditions, the following terms will apply to the forthcoming voluntary redundancy scheme. 4 weeks base pay per year of service inclusive of statutory redundancy entitlement. All successful applicants for voluntary redundancy will receive a minimum redundancy payment of 3 months' base salary. It is envisaged that the above terms will apply in respect of redundancies made by the bank over the next 5 years, subject to an annual review. And finally, in the event that compulsory redundancy become necessary, it is proposed that the terms set out above will apply to any such redundancies. Minister, it is this House that has decided that a special liquidator should be put in place. We were also the people that said that the rules and terms and conditions that people took the employment, stayed there, tried to work out the assets for the states, did an honest day's work, and we're now turning around and saying so far, and I do note that the special liquidator can take guidance from the Minister for Finance to determine whether or not special package can be put in place to fulfil the terms and agreements that were subject to the HR department of IRBC. Finally, before a response, I would like to say that there is currently a piece on the intranet inside IRBC, and it also says that they are entitled to the full voluntary redundancy package as per agreed. In the event that compulsory redundancies become necessary in the future, it is anticipated that the terms set out above will apply to any such redundancies. Any such proposed redundancies would be subject to a separate consultation process with employee representatives. That needs to take place immediately, and it needs to do so in recognition of what has gone on heretofore.
Thank you,
I will give these documents to you this evening, Minister, and to Minister Noonan and to the Taoiseach as well, to make sure that the employees are given what they're entitled to.
Thank you. Minister.
Thank you very much. I'm taking this issue on behalf of Minister Noonan. I'd like to thank Deputy Spring for raising this very important issue. I welcome this opportunity to address the Dáil on the subject of IBRC staff redundancies. As welfare of all employees is of the utmost concern to this government. Liquidation by its legal nature creates an immediate termination of all employment contracts with the resultant impact on the employees involved. The special liquidation order made under the Irish Bank Resolution Corporation Act 2013 is no different from other liquidations, and for employees in IBRC, their employment was terminated with immediate effect following the passing of the Act on Thursday, the 7th of February. There is no doubt that this would have come as a shock to employees in the bank. It is unfortunate that it was not possible to give more notice on this matter, and I regret the abruptness of how this decision was communicated to the management and staff. However, it was imperative to keep the matter confidential due to the scale, sensitivity and the complexity of the economic issues involved. Nonetheless, unlike in other liquidations, it is very likely that the employees will be rehired by the special liquidator for the duration of the liquidation on such terms as he may determine. Most employees have been rehired on monthly contracts. Some staff may be offered positions with NAMA or with other purchasers of assets to continue to manage the loan portfolios. As is common in liquidations, the transfer of the Undertaking Protection of Employment regulation will not apply to the liquidation of IBRC. Again, we would be in the case in the liquidation of an Irish company with foreign subsidiaries. The liquidation of the Irish company does not automatically place the foreign subsidiaries into liquidation. This is the case for IBRC, and the foreign subsidiaries have not been automatically placed into liquidation as they have a separate legal existence. It is up to the special liquidator to decide whether or not to wind up these subsidiaries or to sell them as a going concern. Employees of IBRC subsidiaries, including foreign subsidiaries, have not their contracts of employment automatically terminated. They remain employed by those subsidiaries pending the decision of the special liquidator on the future of the subsidiary. However, this is clearly a very difficult time for the employees of IBRC subsidiaries as they await the outcome of the special liquidation process. Employees will rank as preferential creditors ahead of the floating charge holders and unsecured creditors in respect of certain amounts owing to them on a winding up, including accrued wages and salaries, holiday pay, sick pay, statutory redundancy, pension contributions and claims for damages arising from accidents. Listed below are the instances in which the employees ranked as preferential creditors. All wages and salaries in respect of services rendered to IBRC during the 4-month period prior to the winding up, but subject to a maximum claim of $3,174.35 per employee. It's all accrued remuneration up to the date of the winding up, all sums due in respect of sick leave up to the date of the winding up, all contributions due from IBRC in respect of any superannuation benefit schemes, including PRSA, and any contribution deducted from employees as the date of winding up. Statutory redundancy lump sums, less the amount of any rebate due from the Department of Jobs, Enterprise and Innovation. All compensation awarded by the Employee Appeals Tribunal in respect of pay in lieu of notice and in respect of any claim for unfair dismissal, and any accommodation due under the Workmen's Compensation Act in respect of damage and costs in relation to an accident occurring in the course of the employment prior to the relevant date, save to the extent insured. In the normal course of events, liquidators do not make payments in respect of preferential claims owing to employees until all assets have been realised, which in this case of IBRC is envisaged to take approximately 6 months. In those circumstances, the employees will be able to make a claim in respect of A, their statutory redundancy entitlements from the Social Insurance Fund, and B, arrears of pay, sick pay, holiday pay or pay in lieu of statutory redundancy notice limited to €600 per week up to a maximum of 8 weeks from the Insolvency Payment Scheme. The Minister for Social Protection will rank as a preferential creditor of IBRC in respect of any payment made to employees of IBRC from the Special Insurer or the Insolvency Payment Scheme. The special liquidators will assist any employees in respect of the processing of claims under the Insolvency Payment Scheme of the Social Insurance Fund. And further information in relation to the Social Insurance Fund and the Insolvency Payment Scheme is available on the Department for Social Protection website. In conclusion, I would like to take this opportunity to acknowledge the significant efforts the directors and staff of IBRC have made to the stabilisation and the maintenance of value in the IBRC, and I regret the abruptness of how this decision was communicated to the management and staff. However, as already indicated, it was imperative to keep this matter confidential due to the scale, sensitivity and the complexity of the economic issues involved. Thank you.
Thank you. 2 minutes, Deputy.
Thank you. Minister, with all due respect, the issue here is about fairness, and in the event that compulsory redundancies become necessary, it is proposed that the terms set out will be applied to these redundancies. That's the core issue here. And if we were to look at what has happened to the directors and the people that were senior management that have got redundancies, they have been paid off, a fight that I intend to take on a different day, but they have been done so in a very lucrative fashion. However, those people that put their shoulder to the wheel have a level of expectation that was signed up to by a state organisation, by IBRC, they have to live up to. Here's a little bit of legal advice that has been provided by William Fry. IBRC has been placed in liquidation by a ministerial order made under the Act, called a special liquidation order. Unlike other forms of liquidation, no order or shareholder resolution was required to commence the liquidation. On the making of the order by the Finance Minister, 2 joint special liquidators were appointed. The special liquidators have full custody and power over all the assets and undertaking of IBRC, and the power to carry on its business so far as may be necessary for the liquidation. And this is the poignant piece. These powers are to be exercised subject to the right of the Minister for Finance to give instructions to special liquidators as to the manner in which the liquidation is to be conducted. It is in the grasp of this government to do what is right by the employees, to give them what they are entitled to. I welcome the news that many of them will be kept on and that they will eventually be wound down. But, Minister, what it is all about is fairness. We have a legal framework, but we also have assets that we need to protect. And heaven forbid that we put 15 billion of state assets out to the idea of industrial action, so something that they haven't indicated. But we're putting businesses, we're putting assets at stake, and it's not something that I would welcome. But we need to tackle this, and it is within our capacity, and we should do so.
Thank you, Deputy Minister.
Well, just saying that I don't believe it's fully within our capacity. The special liquidation order was made under the Irish Bank. It was made the Act 2013. It's no different from other liquidations. I have to repeat what the Minister stated here. And for employees of the IBRC, their employment was terminated with immediate effect. And equally, the fact that they're getting as I stated, the benefits that are there. But obviously, the liquidator is the man in charge at the moment. He has complete autonomy with regards to the operation of this company from the point of view of its sell-out and roll-out over 6 months. But equally, the opportunity would be there with regards to other employment. They're getting short-term contracts. They can get a veil of employment within NAMA, and equally some of the assets that will be sold. I've no doubt there will be the book will be sold with the member of staff as well. So I think that, and the fact that they're getting immediate payment, they get the redundancy now as from the liquidation, but they're still employed at the moment, and they will get opportunities. And all of the opportunities that will exist, let's say, with the sale of the asset book and the opportunity in NAMA, I'm quite certain for those that will be seeking banking jobs in the future, there will be, I've no doubt, potential. And even with the financial services in the city here at the moment, really, I think that the outlook wouldn't be as pessimistic on their opportunities of getting jobs in the future. So I think that, and the state is meeting its obligation under the Act. And
thank you. Thank you.
No, I think this is. I think that whatever it was the preamble prior to the date, I think what took effect on the Act was a sensitive, secretive. And very decisive done by Minister Noonan. But what happened prior to that, I think, wouldn't stand from the point of view that the Resolution Act of 2013 is the Act, and that the government have no active role in how that has rolled out from this date.
Thank you. Item number 2.